Oh, yes, I'll go with that.
Thank you. Did you bring a pencil?
Toothpick, chopstick.
It doesn't go.
It doesn't go forward?
We're good.
Okay, thank you. Okay.
Someone's coming.
Oh,
I don't think it's a board member, but I just heard the door.
Dan and,
Oh,
Dan.
Okay.
Congratulations.
We'll give you, Dan, a minute to get settled. Okay. Good evening, everyone. I'd like to call this March 25th meeting of the Hillsdale Borough Planning and Land Use Board to order. We'll begin with the open public meeting statement read by our Deputy Secretary Tanya, followed by the Pledge of Allegiance.
This meeting is being held in accordance with the Open Public Meetings Act. The notice of this meeting was published in 2 newspapers according to law, and time and place of this meeting have been posted in a prominent location in Borough Hall. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. And when you're ready, Tanya, we'll have a roll call.
Chairwoman Cates?
Yes.
Vice Chair Reardon? Here. Secretary Raymond? Mr. Alter?
Here.
Mr. Friedman?
Here.
Mr. Griep?
Here.
Dr. Weinberg?
Here.
Mr. Hipp? Council Liaison Trohimuk? Here. Mayor Scheinfeld?
Here.
Also present, Board Attorney Mr. Liebman and Board Engineer Mr. Sutil.
Thank you, Tanya, and also welcome to the public. At this time, we're going to open the meeting to the public for comment, but this is only about things that we will not be hearing tonight. So if you're here about tonight's application, you'll have a chance to comment possibly once we open that application. So does anyone want to address the board about anything that is not on our agenda tonight? Seeing none, I'll close the meeting to the public, and we'll go on.
Meredith, Chairwoman, we
Oh.
recognize that
yeah.
Secretary.
Yeah, we'll let Tanya, yeah.
Okay.
Sorry for my lateness.
It's okay.
Go ahead.
Mr. Raymond is now present at 7:34 p.m.
Welcome, Scott. We're going on to invoices from CSG Law.
Thank you.
4 invoices for total $1,943.50.
There actually was another invoice in your packet and online that was paper clipped together, so I didn't get it. It was in your packet, and it is for, let's see, it's invoice number 634499, and it's for $573.50. I'd like to approve that as well, so it could be paid.
What's in, I'm sorry, was that escrow account? Escrow?
Yes.
Okay. So 5 bills. Do I have a motion to approve?
Motion.
Second.
Okay, so I heard Reardon and Dr. Weinberg.
Okay, Chairwoman Cates?
Yes.
Vice Chair Reardon?
Yes.
Secretary Raymond?
Yes.
Mr. Alter?
Yes.
Mr. Friedman?
Yes.
Mr. Griep?
Yes.
Dr. Weinberg?
Yes.
Council Liaison Trohimuk?
Yes.
Mayor Scheinfeld?
Yes.
Motion's passed.
Thank you. Moving on, our meeting minutes of March 13th, 2025. If you're in attendance, please review them, and when you're ready, I'll take a motion for approval.
I did send an update this evening changing Chairwoman Cates on page 4.
Tree.
Yeah,
Three?
so
The tree.
What? I'm sorry, Mayor?
No, it was related to the tree.
it has to do with
About the tree, yes.
Yeah,
I
it
thought you were
has to
saying
do
3.
under the
Tree,
tree
tree.
ordinance that the correct committee is the shade tree ordinance, and I was not suggesting we have one. I was just explaining why there was an issue with sort of oversight in this area.
Motion.
Motion, was that Scott? Raymond?
Second.
Second, Seth? Mr. Griep?
Okay. Chairwoman Cates?
Yes.
Vice Chair Reardon?
Yes.
Secretary Raymond?
Yes.
Mr. Alter?
Yes.
Mr. Friedman was not at the meeting. Mr. Griep?
Yes.
Dr. Weinberg?
Yes.
Council Liaison Trohimuk was not at the meeting. And Mayor Scheinfeld.
Yes.
Motion's passed.
Thank you. We'll move on now to our hearing for this evening, which is PT 1224, Block 4103. 1411 Boulevard South, Township of Washington, Sanfone Properties LLC. This is for improved street access. And is this Mr. York?
It is.
Thank you. Welcome. We welcome you. Just,
See how you
yeah.
feel after the meeting.
Well, we welcome everyone. Just please speak into the mic when you're sharing with us.
For the record, Harvey L. York, Novins York, Jacobus, and Dooley, representing the property owner. This is not what one would consider the normal type of application that would be before a land use board, whether it's a board of adjustment or a land use board. It is not a variance application. It's not a site plan. It's an application to allow construction of a home on an unimproved street. And the statute is very clear in what needs to be done to meet that criteria. In this instance, it's helpful to have some history of the property. This lot has existed for many, many years. The actual property is located in your neighboring town of Washington Township. The street, which is the subject matter of why we are here, is split into two parcels. Half of it is in Washington, half is in Hillsdale. When we deal with streets and roads, the statute is very clear, and the statute which governs this is NJSA 40:55D-32. It's part of the official map act. And what happens when towns agree to have streets, they have to go on the official map. And the integrity of that official map is set forth in this particular section, which is section 32, and continues through to section 36, which gets us the appeals. We are here, and the jurisdiction is here, although the property is in Washington Township, because if the property owner wishes to develop his property, he has to use the street. And the street is half in Washington, half in Hillsdale. So the only way he can build on this property is to go through this street. It's the only access point to the property. Section 32 of the statute and section 34 specifically say the statute is designed to protect the integrity of the map. And the map we're talking about is the map which each town has adopted showing your street. And that's the whole purpose of this. This is not a variance. The variances are not in this section. The variances are in NJSA 40:55D-70, way down the road. So this is not a variance application. It is strictly an application to build on an unimproved street. This particular property is isolated. Why is it isolated? Well, at the other end, Washington Township gave permission to a property owner next door to build an extended driveway, which they did on Boulevard South. And they got past their property and they built a retaining wall 10 feet in the air. So you can't drive up Boulevard on the Washington side. Now, interestingly enough, Hillsdale did the same thing on the other side. So the half that's in Washington Township has a house, and the half that's in Hillsdale has a house. So if you go down to Taylor and you look up the road, so to speak, it's not a road. There are two side-by-side driveways. In Hillsdale, it goes 200 feet, the driveway, and in Washington, it goes 200 feet. So both municipalities have previously made a decision that it's safe to build a house at the end of a 200-foot driveway, and there's adequate emergency, fire, et cetera, which is the criteria in this statute. Why are we here? Let's go back again, because the only way to get access to this property is through the street located in Hillsdale. While the property itself is not in Hillsdale, the only street we can use is your street. In terms of this house that we would like to build, it's not a question if the house will be built. The house will be built. There's only two ways it can be built. The municipalities can say, we're going to take Boulevard South and we're going to improve it from where it dead ends now in Hillsdale, and we're going to take it all the way down to Taylor. That's in accordance with the official map of each of the municipalities. So that follows exactly what it's supposed to do. And in fact, in the past 10 years, Hillsdale has looked at that as an opportunity. And there are information that Hillsdale was actually told that's a viable way to proceed. But they didn't. So the alternative to putting the street through, curb to curb, tying it in, is to allow us to have a driveway from the end of Boulevard. Our property touches the intersection of your street. The northeast corner of our property touches the property in Hillsdale. Now, it's a minuscule issue, but it's there. When we tell you and have the testimony, we will prove that both municipalities have already said it's safe to do this. And if you look at the statute that we are bringing before you, all we have to show is that putting the street through would entail practical difficulty or unnecessary hardship, or where the stances of the case do not require the building or structure to be related to a street. Okay, both towns have already agreed we're not putting the street through voluntarily. How do we know that? Washington Township said to the guy next door, you can put a driveway up Boulevard and have a house. And this municipality said to the guy on your side of the street, go ahead, put a driveway through, it's okay with us, and we'll give you a permit to build your house. When these towns did this, both of you, when I say the towns, they accepted that it would be safe for fire protection emergency vehicles to go 200 feet from Taylor to the houses. Now, how do we know that? Because they're there. What about the fact that our lot, the only way you can get there now to fight a fire would be to go through Washington Township, through Hillsdale, around the corner and in? Is that a problem for the firefighters of Washington? Well, obviously, the town made a decision. It would not be a problem. How do we know that? Because they blocked off the boulevard. They said, nah, we'll get there the other way. We're going to take that. And Mr. Sandstone, the only way you're going to fight fires is you're going to go around. So the statute clearly envisions this type of activity. Now, what is the criteria? The board can direct the issuance of a permit subject to only several conditions. And those conditions are, and I quote, conditions that will provide adequate access to firefighting equipment, ambulances, and other emergency vehicles necessary for the protection of the health and safety, and that will protect any future street layout shown on the official map or circulation plan. So what are we proposing tonight? We're taking and doing the exact same thing that both Hillsdale and Washington Township granted on the other side. We're asking you to allow us to have a driveway from the end of Boulevard South to our client's property. But we're not asking for 200 feet. We're asking for a little over 100 feet. So whatever deficiencies there might be and concerns about the emergency vehicles, we're half the distance that you've already approved. So to deny our client that right would be to deny them the ability to build. Now, your planner, in his memorandum, came up with several interesting comments. First, and I have a legal question, is the planner's report marked into evidence?
It's part of the record.
Yeah, okay.
We can just refer to it by its date, March 24th,
Okay.
2025.
So your planner says the relief being requested can only be granted by the municipality in which the lot is located, and therefore the Hillsdale Planning Board does not have jurisdiction. That's not the law. That's a bold statement by the planner with no statutory authority. And it flies in the face of what is available and what has happened already. Hillsdale's already approved the house across the street. So when we talk about these driveways, one is a house directly next door to ours, and the other one is across the street. So it can't be a health, welfare, safety issue because it's already approved. The comment that this should then go to the governing body is, again, without statutory authority. The only one that can grant this permit is this board. There is no other agency in the state that has legal authority. Now, what about going to the council? I will represent to this board that before I even began this project, I sent letters to the mayor of Hillsdale. I sent 3 separate letters over a 6-month period and got no response. After 6.5 months, the borough attorney called me. We had a wonderful conversation, very cordial, and he told me that Hillsdale wants nothing to do with my client's property. Go deal with it. We're not getting involved. So while your planner says, well, go talk to the governing body, that's the same nonsense that's happened to Mr. Cianfrone for the past 50 years. Everyone has said, we're not going to deal with it. Go someplace else. And in fact, your engineer, 6 years ago, has a memorandum in which he suggests to the then mayor that the street should be improved all the way through, so that the entire area would be a horseshoe street. You'd come around Crest, go down, and back to Taylor. Nothing's happened. So we're now at the point where our client has taken the last gasp of trying to develop a property he's owned for 40 years. Oh, and he pays taxes. At this time, I'd ask that our witness be called, Mr. Matt Hockenberry.
So before we even can get to that, there are some, I think, very interesting legal issues that this application presents. And while the statute may allow a zoning board to grant relief from the statute, it's pretty clear that even if the board were to grant that relief, that still doesn't get the applicant the right to develop the property, because this board has no authority to give your client the ability to build a private driveway on a public right of way. So I think that that is a potentially serious jurisdictional issue that the applicant faces. The understanding I have of this street, Boulevard South, is that it's paper street in the area that you're looking for access. Half of this paper street in Washington Township is unimproved, and part of it's improved sort of with a private driveway. And it seems that the relief that your client really is entitled to, he's entitled to from Washington Township. And my understanding is that, from what I understand, your client has been treated rather shabbily from Washington Township. I don't understand why Washington Township doesn't improve its own street on its own publicly approved roadway to provide access to its lot that it's taxing your client on and not giving him access to. So I do think that there are some interesting procedural, jurisdictional issues here, Mr. Moore. And my request really would be that you argue them in writing to the board and give me an opportunity to flesh it out a little bit more fully so that I can advise the board on how best to proceed with this. As I read the statutes, we have 120 days to decide this application from the time it was deemed complete. Do we have that date, Mr. Steele?
Well, I would have deemed it complete, but the board would have to actually vote on that completeness.
Do you know, Mr. York, when the time, I don't want to blow the time frame
I
and have
do
you
not
bring an
know.
action.
We think it's February
I know-
3rd.
I know that the application was filed on November 1st, 2024. I can't tell you when it was complete. I can tell you that, maybe I can.
Well,
There's not, all the information was,
Yeah,
I received it on November 4th. All the information was actually received on December 20th.
yeah.
Okay, so we have.
Our secretary takes excellent notes, and the full information was received on the 20th. We think we deemed it complete.
December 20th.
December
It was to
20th.
be complete
February 3rd.
It was
and-
complete February 3rd?
And
Yeah.
120 days would be June 3rd.
Okay, so we have adequate time. And this is an interesting issue. And I think more commonly, this relief is seen when somebody has an easement that they're going to get to obtain access to the back property. That's more commonly what I've seen in my practice. This is a little bit different. So I'd like to just take a deep breath. Let's analyze this legally. Let's come to the right conclusion. I understand there's litigation pending with Washington Township already. Can you give us a little bit more information about where that is? 'Cause
Sure.
I've just heard sort of rumors around town. I'd like to hear from you.
Well, it's easy. We went to the Board of Adjustment. They turned us down. We filed a prerogative writ suit against them. We then expanded the lawsuit and filed a suit for inverse condemnation. Legal term? The answer is, you're not going to let us get our property, then buy it from us. Telling the township, that you'll have to buy it. That then got stretched out, and it's my understanding the borough of Hillsdale is now a party to the litigation. David, am I correct? I'm just getting my partner's son to give me that answer.
It's
So
my-
today,
Right.
as of today, the borough itself is a party to that litigation.
And is the borough a party because Washington Township sued Hillsdale?
Yeah, I think
Because-
that should be clear,
Yeah.
why
I
Hillsdale
will
is
have
involved in the
my
lawsuit.
litigation partner
Thank
talk
you.
about that.
Can you please identify yourself?
Hi, David York, Nova George, Jacobus, and Dooley, on
Actually,
behalf of the
it's
applicant.
my son, but
Great,
that's
thank you. The current state of the litigation is that the original lawsuit was filed against Washington Township Zoning Board of Adjustment, as well as the Borough of Hillsdale. Subsequent to the filing, we, the plaintiff, dismissed the Borough of Hillsdale from the litigation. Thereafter, the Township of Washington filed a motion to bring the Borough of Hillsdale back into the litigation, and the judge granted that motion about 3 weeks ago. So the Borough of Hillsdale itself is back in the litigation, subject to a cross-claim from Washington Township, not subject to a claim from our client, the applicant, the
So
plaintiff.
Washington Township is seeking relief or damages from Hillsdale because of a problem that they created by giving you no approval?
Well, I'm not going to characterize it as you would. I'm just suggesting the emphasis, or the point of the motion, as I read it, filed by Washington Township, was that they believe that Hillsdale, the Borough of Hillsdale, has some type of liability to our client. So we dismissed the case against the Borough of Hillsdale, because we had never been before the Borough of Hillsdale on a formal application. That's why we are here tonight, to have a formal application.
Can I ask you to get me a memo on the jurisdictional issue that we're here, and send me a copy of the pleadings in that action?
Of course.
So I can fully understand this, just procedurally where we are.
Correct.
And then
No
let's make a decision whether we're going to proceed and how we're going to proceed. When is our next meeting?
We don't,
That's too soon.
Okay.
22nd, but we have two things on that night, but they're not long. One's the subdivision.
Let me see.
Yeah, I have it. The 22nd, we have the subdivision, and we have Cantor returning.
Okay.
They won't go away.
So,
It's their fourth trip to us.
so is that enough time for you?
The 22nd is fine.
No, can we talking 22nd of April? Yeah. That won't work for us. At my age, I don't get a lot of
Yes,
vacation.
the Board of Adjustments.
We I have it.
50 years, another day or two won't matter.
What's the following?
So I understand it's Earth Day, so that could be important to you. May 8th is our next date after that, May 8th. That's a Thursday. Do you want to check?
Well, May 8th is, unless we do some of it, but May 8th is fine.
Yes. We have till June 3rd.
Yeah. Just one more thing, it occurred to me, there was one additional piece about the litigation. About 4 or 5 months ago, we filed a motion to amend the complaint to add the adjacent property owner to our client who lives in Washington Township as a defendant. That motion was granted, and only a few days ago, that the adjacent property owner filed an answer in the litigation, so they're involved in litigation as well.
Do you know if they filed cross claims or third-party claims against
They,
Hillsdale, for example?
I believe there is a cross-claim against Hillsdale. I don't recall the basis. And there was a counterclaim against our client for malicious use of process because in the complaint, or in the counterclaim, it said that the Township of Washington had granted them an easement to use the driveway.
And there's, of course, no recording, which,
We haven't seen that.
okay, I guess this is what we have judges for.
No, it's the way of lawyers.
All right, so I guess if you could get me something, say, 2 weeks before our May meeting, so that I've got time to digest it and respond, and I'll give my written legal opinion in response to the board, and I'll send a copy to you in advance,
Sure.
so that we can fully flesh it out.
All right.
Should we announce? No.
Okay, so this matter is not going to be heard tonight because of the jurisdictional issue that we're going to address first. This matter is going to be continued to May 8th at 7:30 p.m. in this room. There will be no further notice. Nothing's coming in the mail. Nothing's being published in the newspaper. This is your notice.
Okay. Thank you, Mr. York. Thank you, Mr. Liebman. So I think anyone interested from the public, you heard the next hearing on this matter will be May 8th. Unfortunately, you can't speak on the matter, this particular matter. You'd have to come back on the 8th and speak on it. We have to have both parties fully here, and they have to be present. You can approach the board about any other issues, though. Yeah, there's a part of the hearing where you can come up, but because we're not having a hearing, we're going to have to wait till the 8th. You can also, you can write to the board. You can write to us if there's things you want on the record. They can write.
Anything that anybody wants on the record
Well, I mean, that would be part of the
has to
meeting.
be here.
Right.
If they send a letter, we're not putting a letter.
It's circumstantial.
No, they'd have to come up and
Yeah, they
speak.
could come
They'd
up.
have to come up and speak, but I'm just saying, yes. They'd have to come. No, you know what I'm saying. They'd have to speak. All right, thank you.
Thank you for coming.
I mean, sometimes they written and just prepare something to speak. Okay, thank you, board. So we're going to move on. We just have 2 short discussion items, and this is following up from our discussions items last week. So checking on the status of our, all right, excuse me, we're just going to continue to meet, so please talk in the hallway if you would like to talk. Thank you. So Mr. Reardon, I believe you edited the checklist and sent that on to, was it the full board or just?
Just to Tanya, yourself, and Mark, I think we had the board vote just to agree that we were just going to add what we discussed last time. No further action needs to be taken. I just want Mark to see the number 4 that I amended, adding verbatim. It says the 200-foot list acquired by the tax assessor can be no more than 6 months at the date of application. I think that's what it was. But if we had to finesse that, that's fine, but it'll be, I think, finalized for whatever we have to do.
Yeah.
Steve, was that sent out to the entire board?
No.
No, because I was afraid Chris Steele would make me add something else, and I just couldn't fathom that happening again. Thank you.
Yeah,
And one
so
page won't happen.
Mr. Lehman's going to review that. You can copy the board once it's sent on. It'll be sent on to, you'll send it on to Medea?
That's all you do. Okay. Yeah, that's fine. Okay, I'll send it to Mr. Medea right now.
Do you want to just read maybe what it says so the rest of the board can hear? If not, I can get it out.
You want to read the whole thing?
No, just the number 4.
Yeah, just the new
addition.
one.
That's all that was.
A copy of the 200-foot property owners list, hyphen, the list must have been acquired from the tax assessor within 6 months of the application date.
That's it. Simple, straightforward. That's it.
Yeah. I'm just going to review that for Dan, since he wasn't here last month and he could not hear. So Dan, what we did at the last meeting was it was recommended that we make sure that our notices, our list is within 6 months. We make sure that it's 6 months updated. So that's what we're adding to our checklist. Okay. Any other questions? So that'll be sent on to the borough attorney. And then our checklist can be voted on, scheduled and voted on. Well, let's see if the mayor was here. Okay, so our other item, I believe we have a tree ordinance meeting scheduled. Is that correct?
We do, I think Thursday.
For next Thursday?
Yes.
Okay, and then we'll report back to the board following. I have no other discussion items. Does anyone else have a discussion item? Yes?
Is it next
I
Thursday?
know I can't do it in private, but if I have a question about what just happened, I mean, I know I can't do it privately, but
You're allowed to talk to our borough attorney.
call you?
Send me an email.
I mean, it's not, but it's something that would,
So our attorney's going to update us as well. He will prepare something for us all.
can I say the question, or? and you
No,
can
we
decide
can't
what-
talk about a hearing when it's not
Okay.
going on now.
Okay.
Yeah, okay. Whenever there's a hearing that is not standard, we can trust our professionals will guide us as to the next steps. So that's part of the fun of planning and zoning. So good news is, I don't think we have anything on the agenda for April 10th. So it looks like we will not be, I will have to open to the public. Seeing none, I'll close the meeting to the public. So our next public hearing will not be on the 10th. It will be April 22nd. And we have, looks like now, we still have our 2 items. So,
Are
Say
you-
Meredith,
Sorry, go ahead.
April 10th, yeah?
Are you,
April 10th. What did she say?
are you just recusing yourself for the first one and then coming back on for the canter, or what are you going to do? Or are you just
we
going to
can
take the night
discuss
off?
that. Yeah,
Or-
it's my husband's birthday, so I may take the night off. And I
Take the
know
night
you
off.
would be very happy to chair, and my husband would be happy if I don't chair. So.
Is it the 10th where you're canceling?
It's the 10th we're canceling, which is, it's right before the holidays, so.
Very
that's
good.
as far- Yeah.
Thursday, April 10th.
Thursday, April 10th, yeah. Okay, everything clear? So if there's nothing else at this time, I'll take a motion to adjourn.
Motion.
Mr. Alter, second. Thank you, everybody.
All right.
That was, I think, who seconded that?
Easier
Ed,
than I thought tonight.
and then Scott. Scott and Ed, sorry. It was hard to hear. Thank you, everyone.
Hold on, I need to,
Talk about that. You